Well, I am delighted. We're going to be shifting gears pretty substantially here, but that already was absolutely fascinating conversation. Hi, good to see you. That's absolutely fascinating conversation that just unfolded, and I really love the way that the conversation just evolved and took these organic directions that then circled back on themselves. It was a really wonderful discussion, and I'm delighted to turn things over now to Ann Bartow. Ann is a law professor and also a WeRobot alum, and has contributed mightily in years past, and we're delighted to have her be our discussant today for a paper by Anupam. Oh my God! Sorry, I had a brain fart there. But this is interesting because I think it is, if not, I think it is the first WeRobot paper to examine in depth the international perspective, not necessarily from the perspective of autonomous weapons, right? And so, obviously there are lots of interesting challenges that occur that when you cross over borders, especially international borders. And so we are very honored to have a deep expert in the intersection between international law and technology, talking about what happens when you cross over borders. So with that, I will turn it over to Ann. Thanks.
So it's great to be here, and it's great to be commenting on Anupam's paper. Anupam's an old friend, and I've long admired his work as well, so it's interesting to see him shift gears and get into this. The directions for speakers, which those of you who are speakers already know, said no PowerPoint, but Anupam brought PowerPoint because he's a subversive. But that's okay. So I was thinking back on, I did a Fulbright year in China, and Anupam and Madhavi and both kids were there, and it's been set up by Hatch and Son, a mutual friend, said, they're going to be in China. I was in Shanghai, you should show them around. So I picked them up at their hotel, and I said, well, what do you want to see first? You want to see Pudong? You want to see the Bund? You want to see Yuyuan Gardens? And they said, we'd like to see the counterfeit markets. For research purposes only, of course. We had a lot of fun. So I have a son, he's 23 years old. Anupam has younger children. Some of you, children of your own or children in your lives or all those sorts of things. So you're familiar maybe with some of the things we can't import to the United States because of concerns about children, especially if you've traveled. So when my son was 5, I got this great teaching gig in Greece for the summer. And 5 years old, I had to keep him occupied. He was just there with me, especially when I was teaching. And we found these things called Kinder eggs. Do you know what Kinder eggs are? So they're a chocolate egg, not just for Easter, all year round. And the chocolate is like really disgusting, but you're not into it for the chocolate, especially in the summer in Greece, as a melty mess. There was an unbelievable toy inside. There was a little plastic capsule and an unbelievably nice, interesting toy that really kids really like. But they're not allowed. You can't have them in the United States because the toys are very intricate and interesting and small parts. And the idea that Kinder Egg is marketed to children and children might swallow those is a big problem. More recently, and there's actually a law review article about this by Anita Bernstein, buckyballs. You know buckyballs? They're these really small round magnets which are unbelievably fun, and you can do all sorts of interesting things with them. And apparently, at least some child decided one of the interesting things they wanted to do was swallow a buckyball. So buckyballs can be imported anymore. And I was recently in France, and they had a toy stores, and they were. My son collects Pokemon cards from all over the world, so I was looking for Pokemon cards. And there was these buckyballs, so of course I had to immediately get some, just to sneak them into the United States and also be a subversive. But against this backdrop, you wonder why we have so many things with small parts. Why you get fixated on certain things and not on other things, right? Because how many of you in recent memory have seen a thumbtack? That's small, right? It's small like Kinder parts. It's small like a buckyball. In my family, family legend goes, when my sister was a little kid, she actually ate a thumbtack, and someone picked her up by her hands and shook her until the thumbtack fell out. In other versions of the story, it was me who did this, but I'm sure it was my sister who actually did this. So against this backdrop of what we let in and what we let out and why, and is it irrational, and what's the backstory, we get from Anupam this story about goods, right? His article is entitled Robot Passports, the idea being little robots like the bugs we just saw, or big robots, and for different reasons, would they need a passport to cross national borders when some countries have this irrational fear of small parts some of the time and other countries don't? So Anupam's article, one of my critiques of the article actually, because it's a work in progress and things are being workshopped, is that he compares robots and sort of the Internet of Things and goods. And in fact, the most common example he uses in his article is actually the Fitbit, which I guess might fit some versions of a robot, but I don't really personally think of that as a robot. I'll talk about that more in a second. But he kind of blends the two. So it's fine because everything he says about technology applies to robots. So to that extent, it's perfectly fine, and I really enjoyed the article. But I'm going to push you in the future to add some more robust robotification to your analysis, because as Anupam, if you read his race on race and the law, you know that Anupam would never say, well, race is in there because it applies to all humans and everyone has race. You know what I mean? Like he would never kind of gloss race over. So I urge you to bring robots more to the forefront. So what Anupam talks about is that there's a dependence, especially with trade, on global free flow of data. And he says that this free flow, for a lot of reasons, right, not necessarily relating to robots, but can be jeopardized by, among other things, two really important constructs: privacy and security concerns, right? We've already seen that. We've already seen privacy concerns and the security concerns throttle like a free flow of information in different contexts. So Anupam, one of the questions he asks is there a way that international trade law can intervene productively in all of this? So that's one of the questions he's trying to answer with the article. So he mentions that data about us is collected all the time, and that offers us benefits and risks, right? There's some data we appreciate having collected about us that can lead to different positive outcomes for us and things that we do in our lives and make things easier, faster, etc. And then other times we're not really happy about it, right? There are risks with data. We don't want stuff collected, or if it's collected, we want it confidential. So a lot of different things can happen. And then he integrates this analysis of the Internet of Things. And he says about the Internet of Things, these are objects with sensors, and they have sensors to understand sort of features of the environment and an ability to communicate. So that's just the Internet of Things. He says they understand the features of the environment and they can communicate. And then for robots, his definition of robot is either, well, at one point it's arms and legs, which of course, I know you're sort of a little tongue-in-cheek, but it was more an ability to affect the environment, right? It's a little bit beyond that. So that might be one definition you develop more in the paper. He talks about analytics via large cloud computing infrastructure and how important that is to robots. And we've heard in other contexts already about cloud computing and robots and some of the new things that are developing there, that's really important. He says it's very important for robots then that this crosses boundaries, right, national borders. He says smart objects create opportunities when this happens for protectionism, because sometimes things might be rejected at the border due to concerns about embedded data flows and either potential or even real privacy and security concerns. So he says it's these concerns that can lead to information barriers, and these information barriers can be goods barriers, right? That actually goods can be stopped at a border based on concerns about the embedded technologies, what they do in terms of things like privacy and security. He references Jagdish Bhagwati's law of constant protection and says that no matter what, you can take one barrier down and another one will arise. He uses as an example that the Chinese government has banned the purchasing for government actors of Apple computers as a barrier. So Apple has less of a market, although maybe that's it's sort of a buy Chinese initiative too, right? That they looked them to buy the Chinese technology. So that's a little bit mixed, but it functions as a barrier anyway. So you can strike a practical barrier, and then sort of this other barrier, this sort of more subtle approach, comes along. Then he asks a question, which is, I think, fundamentally unanswerable, but that needs an answer when you go case by case in trade disputes, which is a smart object, which might or might not be a robot, a good or a service? Because if it's a good, they'll be usually subject to more liberal trade policies. So usually a more liberal trade policies, if it's a good, less if it's a service, and if something looks like it's both a good and a service, that can be really complicated. He mentions that in a GATT dispute previously, a magazine, not necessarily a smart object, became the subject of this inquiry. Because if you think of a magazine, it's sort of a vessel for information, it's a vessel for advertising, and the people who were buying advertising in the magazine thought they were getting a service, right, a way to reach out to people. But the competing argument was that a magazine is a good, even if it's online, that it's like a physical magazine enough that we should treat it like a good. So these are just, it's just a hard question. It seems to fit both. There's no absolute answer, but you need an answer if you're going to figure out which rules apply. So then he gets into the fitness tracker examples, like the Fitbit and the like. I can't even remember what the other ones are called, but I know people have their other. Yeah, there's a few of them, and people seem to be really partisan about that. I don't want to start any wars about that, but I'll just say a Fitbit for brevity's sake. So he talks about fitness trackers, and one of the things they do is they collect your health information. So stuff about your sleep, I know, your sleep cycles, and some of them will wake you up. They pick a good point where you're going to feel less groggy if they wake you up at a certain point. How much movement you do, all the exercise, all those sorts of things. People like to track that and share it with friends and all that. I can't think of anything more boring, actually, personally, than finding out how many steps my friends took every day. But, some people are really into it. And but other people want to keep this information private. They want to do it for themselves to sort of keep up with their own fitness levels or learn more about themselves, but they would prefer that it not be shared with anyone. I know I have a cell phone that has a pedometer, and periodically I just leave my cell phone at home, and it thinks I'm the most lazy slug. I get these nasty messages the next day, you must move more for good health, because my phone has just been laying around. So I don't really particularly want to share that with people. But so the question then for the Fitbit is, what if you have a country, and he uses the example of Australia, and Australia says, we like Fitbits, we want our, Aussie citizens to be really, up and moving around and record this and keep track of their steps, but we give lots of privacy by law, and the Fitbit stores the information in the United States where, guess what, there's really less privacy protections. So in the interest of looking out for our citizens, we're happy to let fitness trackers in, but only fitness trackers that either store their data in Australia, where they're subject to Australian laws, or maybe we would consider if they, terms and conditions, like enforceable terms of conditions or something, another country, as long as it rose to the level of Australia. But this then becomes kind of a strange question, because that becomes Australia would have the option of banning things for like morality or health or whatever of Australians, but does a Fitbit really qualify? Because is health privacy, like how many steps you take every day, really a public health issue? Is it really a moral issue or not? So I don't have an answer. Anupam, at least in this draft, doesn't have an answer, but he just lays out the dispute that this is the kind of thing people are going to argue about, because whether it qualifies as under public health or not gives Australia the tools, right, to protect people's privacy or not through trade barriers, right, through not allowing stuff in and not allowing stuff out. So we also ask, when you talk about this, is it a health service or is it even a computer service, right? Even moving away from moral concerns, do we categorize the Fitbit as a health service or a computer service? And because that's going to also make it a difference in terms of what countries can do in terms of controlling trade across their borders. And then he asks, well, maybe this always should be a default, since it really could be both. Maybe the default answer should be, it is whatever leads to more liberal free trade, right? Whichever allows more crossing of barriers, of boundaries, that should be the default if we're really committed to free trade. So it's a great start to a paper. It's really interesting. So a couple of the questions that I have just to start off, and I'm sure you also have a lot of questions for Anupam, is first, and it's a draft paper, but like what your sort of normative component really is. So you raise a lot of questions, and like I haven't done it justice in terms of the way he very meticulously sets up the kind of issues that can come up, and then the possible answers that we might have, and how it sounds so simple, but it actually gets really complicated fast. So a fundamental question, I'll channel my inner Joel Reidenberg, is, why shouldn't countries be able to control their borders and protect citizens? If we're going to talk about defaults on free trade, I don't know in this paper or not whether Anupam really needs to kind of address. He just may say, just assuming free trade, go forward, and I think that's okay. But there's a lot of really interesting literature about boundaries, of course, the Internet of the Information boundaries, the goods and the services. And that, once I wind up, gets me back to China, gets all of us back to China, which is one of the things, of course, in recent years that has happened with China, is basically increasingly in trade negotiations, some involving intellectual property, some not, is that increasingly China's attitude is, we are so big and so rich, we're going to do whatever we want, just like the United States does, right? So in the long run, it's not really clear how many countries are going to be impacted if a might makes right sort of is increasingly the paradigm.
Well, thanks very much, Anne, for those brilliant comments. And all of them are right on the mark. So thank you so much. So the paper tries to imagine robots in a kind of international context, right? I'm an international lawyer, an international economic lawyer. In particular, I do kind of cyber stuff. And so this is intersection of my interest. And as Ryan pointed out, when most of international lawyers think about robots, this is the vision they have in mind. So it's the vision of Pacific Rim. I saw monsters, and this is their ad. Actually, I ran. So when you Google robots and countries, this is the first thing that comes up. Okay, so these kind of autonomous weapons of mass destruction, kind of marauding across the world. That's the paradigm under which these things are typically understood, and that's not the paradigm that I am approaching this question. And so this is obviously a very important question. Don't get me wrong. Greg McNeil here is thinking about these issues, and I think there are lots of others in international law doing great work on those kinds of issues. So I'm thinking more about the peaceful use of robots, and my paradigm is more something along the lines of this. This is the Komatsu Caterpillar type vehicle, one of these huge vehicles that is connected to a big server farm somewhere else. And so the concept in this paper very much kind of picks up on the way that Ryan defines robots in his recent paper, things that sense, think, and act. And in this context, what I say is that this is all done often across borders. The sensing, the thinking, the acting is often done across borders. That may be harder for us as Americans to recognize. Okay, because of much of what we do is homegrown robots with homegrown companies performing stuff at home. But the reality of the world is these robots go across the world, and the other reality is that we will be buying these robots from across the world. And so that's the context in which I'm thinking of this. And so sensing is, of course, performed locally. The sensors are local in the country in which the physical robot or the object exists. But the results of the sensing, let's say the Fitbit data, the Komatsu data, etc., are often stored far away in some server farm in a foreign country. Even the thinking is often performed offshore. And Ken Goldberg talked this morning about cloud robotics and the increasing importance of utilizing the scale opportunities available in the cloud. And this is the way Google robotics is typically functions, right? Google has these massive, small numbers of small computers, parallelly connected through parallel processing, but that create this enormous cloud that could be residing anywhere. And so when Google thinks of robots, it's thinking largely in those kinds of terms. And of course, you need to have, thinking occurring, on board as well for certain circumstances where the internet connection might die. But in general, this kind of remote thinking is very much a part of robots. And here, I reference in the paper. By the way, I have now, just for those, I finally conceded to the norm of WeRobot, and it's now public. Even though it's a working paper, it's available online. I typically avoid putting my working papers online to the world, but it is now available, or it soon will be available on the web, on the WeRobot site. Third, of course, the acting may be performed locally, but the direction yet may come from abroad. So all these things implicate a kind of cross-border robot, and so the question that I've been kind of thinking about is that as robots are crossing borders, sometimes physically, sometimes virtually, how is international law, how are borders affecting this kind of border crossing? And again, not in the autonomous weapons of mass destruction context, not in the Transformers marauding the world context. And so I'm working on both sets of issues. The paper, as it's currently drafted, focuses, of course, on the virtual border crossing. So that's the kind of approach that I'm taking in this paper, and it's as you'll see, a highly technical paper. In fact, it's very much the kind of technocratic trade law question that it ultimately poses. And let me turn to Anne's important questions. First, one of the moves I make in the paper is to couple the Internet of Things with robotics. And this is a kind of ontological question that I think is worthy of further discussion and scrutiny, and perhaps you'll let me know where I'm wrong or what else I need to think about. So in this context, what I did was I paired the two and coupled the two and treat basically the two as having the same effect for my purposes. For the purposes of my analysis, I create a larger category which I call smart objects, and run my analysis through that larger category. Okay, so that's the kind of important move that I make in the paper that I'd welcome commentary on. But the question of what is special about robots versus the Internet of Things is an important one, and it may well, the kind of acting upon the environment maybe in a kind of mobile setting or something along those lines might have some particular legal consequences that I think I maybe haven't kind of grappled with as yet. So I'd be delighted to have your thoughts on that. But Anne asks a fundamental question: what's the kind of normative goal of this work? The normative goal is to essentially say, look, we've had this huge kind of development of international trade in goods. Okay, so the last century has brought us enormous riches across the world because of the increasing free flow of goods. Okay, so that is, I think, as obviously there are people who worry about that and those kinds of flows, but in general, I embrace that kind of flow, and so the flow of goods across borders I see as beneficial to countries across the world, and so this is a fundamental kind of normative vision of the paper. And what I suggest in the paper is that this flow is actually quite at risk, because it turns out that as goods become smart, as all these things that are being transmitted across the world become internetified in some way, as they sense, as they store, as they think, as they remember, as they think, those features are subject now to a new set of regulations. Okay, and then offer a locus for playing with for regulators who are always keen to protect local goods manufacturers, to use those features as the locus of regulation to push the foreign goods away. Okay, that is, this enormous free flow of goods that we've seen stands at risk of being seized by border inspectors or other inspectors who worry about the information content passed through those goods. Okay. None of that is to say, and so this gets back to Anne's other crucial question. So how do we protect our citizens? Okay, so we're all concerned about information and its protection. Woodrow's piece tomorrow is going to be worried about these kinds of issues. These are all really important questions. Regulating consumer safety is a key feature of why we have governments at all. right? And so we want governments to regulate consumer safety. And so we don't leave that entirely to a system of buyer beware. And that is also a normative principle I accept. But that's also a fundamental principle of free trade law. Okay, that is, regulatory autonomy is in fact part of what free trade law accepts. Despite what I'm assuming that most of the people in the room, I know Margot here is a trade lawyer, international lawyer, but most of you, Robert Post has written on international law, etc. But most of you probably don't do international trade in particular. And so if you have any kind of perceptions otherwise, international trade law does have enormous respect for regulatory sovereignty. But the worry, of course, in this context, and going back to my normative concern in this paper, is the manipulation of domestic regulatory goals to mask the protectionist interest that's really motivating the protectionist goal. I'm sorry, the regulatory apparatus. And so the argument in this paper is that we need a way to smoke out the kind of protectionism from the appropriate regulatory consumer safety regulation. And so what we want is a world where we can have free trade and regulatory sovereignty and consumer protection at the same time. To have our cake and eat it too. That is, benefit from the free flow of goods and services, but keep a measure, a full measure of consumer sovereignty, of regulatory sovereignty and consumer protection. So, how do we achieve that important balance? That is the heart and struggle of international trade law. That is really, specifying what the controversies of international trade law are all about. And so this paper tries to begin that analysis. The fundamental normative vision of the paper is that just as we wouldn't say that a good is safer or only safe because it's made here, or it can also be safe if manufactured somewhere else. The information service that the good may have can also be safe if provided from somewhere else. That is, something that is written to be to disfavor foreign information providers is inherently at odds with an international trade regime, even one that protects regulatory sovereignty, because you don't need things to only be safe. Things aren't only safe if they're manufactured here. We could have had a world where we said only toys manufactured in the United States are safe for Anne's or my kids. And so we haven't done that, right? So we've clearly said you can provide these goods from anywhere, but it's consistent with regulatory sovereignty to say buckyballs will be barred at the door because our regulations have found them to be, in our view, unsafe for children's consumption. Right? Children's use, I should say, not consumption. Clearly unsafe for children's consumption. The word consumption has multiple meanings, and I don't mean it in the particular way that it sounded. And so the argument in the paper, and the paper is, as you'll see, not fully finished, is going to make it clear that the foreign aspect alone should not be the basis upon which you refuse entry. In that sense, it's something akin to the initial move, and Ryan will appreciate this, that electronic commerce law made in the 1990s, first at the international level of all things. People may have forgotten this. The UNCITRAL Convention on Electronic Commerce in 1995 said basically, so the question in the 1990s was, could you have a contract online? Okay, how can you have a contract? I thought you had to sign it, right? How can you sign something online? So the worry in the 1990s was we'll never be able to engage in contracts online. They'll always have to have a physical component. So you can't communicate with the people and enter into a contract binding that's enforceable, that's legally valid across jurisdictions. And the UNCITRAL Convention said, you can't refuse to enforce a contract because of its electronic nature. Okay? And we incorporated that into our own laws at the federal and the state level in 1999. And so we passed a number of statutes that said exactly this. In other words, they didn't say that an electronic contract was automatically enforceable. They said it could not be not enforced because of its electronic nature, right? So that move right there is one that I'm borrowing from in this kind of system. That is a move that says you can say something is not a contract even if it's entered into electronically, but you can't say it's not a contract just because it's entered into electronically. All right, so I'll stop there and welcome your comments and suggestions.
Questions? Well, David?
Yeah, I have a question. David Post again, from Open Technology Institute. I guess I have two questions. One is just to you as an international, someone who knows something about international law, about which I don't know a great deal, international trade law. The debate between, or this crucial distinction that Anne points to about goods versus services, we have to figure out is this a good, is this a service? Is there a category of information that is distinct? What we're worried about is the collection of the information, whether that's in the good. So it's not a good and it's not a service, it's not good. And I've always been struck by what I think, again, as an ignoramus in international trade law, but what I think is the inability to deal with information as a separate category from goods and services. So that's one question. Second question is, are you throwing kind of the baby out with the bathwater a little bit? You're so concerned that this will be used as a pretext. Sounds like you're so concerned that this is going to be used as a pretext for simply doing the protectionist thing that governments always do with respect to the flow of goods and looking for any reason to staunch the flow of cheap robots coming in from China and Malaysia or whatever, so that we could stimulate the domestic industry. But yet, at the same time, there are the shipment of information overseas in the aggregate. If we have bank security robots, I guess I'd be a little concerned if that information was falling into the wrong hands, aggregated all together and made use of. So there is a real concern about this cross-border. I mean, there's a regulatable interest, I assume, in this cross-border stuff, and I'm wondering if you're tossing that out because you're so concerned about the pretextual use of it.
Great. So, David, thank you so much. So is information a separate category at all? And maybe we should think of it that way, I think is also perhaps David's suggestion. So not in the WTO's infrastructure as it stands today. So it's goods or services, right? And in the paper, I suggest essentially that these are hybrid objects that carry both goods and services components to them, and therefore we need to apply both liberalization regimes to these things simultaneously. And so there's how that works. The relationship between the two is quite interesting. In some of the new agreements that are being negotiated, there are special provisions for free flow of information. And so it's actually a key part of the U.S. Trade agenda. So global free flow of information is a huge part of what the U.S. is arguing for across the world. And so in that sense, yes, there's some kind of new category that is arising in these other fora that the U.S. is creating. No in terms of WTO, yes in these new agreements that are being contemplated at the moment. And Margot, I'm sure, will talk more about that. And so, second, you're concerned about your financial information. And so of course, so am I, so is everyone here. And so we're worried about identity theft, all this fraud that's going on, etc. But the first thing I'd say is, it's clear that none of that, your financial information is not necessarily secure just because it's sitting in the United States, right? That's the fundamental logic of international trade law. We could have had a world where we said, we'll only consume food grown in the United States. And Canada might have said, we'll only consume food grown in Canada, et cetera, and go across the world in that way. But of course, we realize that we can buy food safely from elsewhere. Okay. It can be unsafe coming from there, but it can also be unsafe coming from home, from California. We've had a lot of deaths from food produced in California or Iowa or wherever it is, right? So just because it's produced from domestically doesn't mean it's safe. Just because it's produced from abroad doesn't mean it's unsafe. And so in reality, what produces safety? Competition produces safety, and government regulators evaluating these the quality of these things. So competition among various providers is a huge part of producing safety, and competition among regulators to demonstrate that they are creating a safe environment for their consumers is important as well. And so I think those are the ways that we should protect our financial security. So if we think that generally we've just made things safe because we've kept them in the United States, that I think is foolhardy. It's similar to thinking that things are safe because they're kept in your house as opposed to somewhere else outside your house. You may have more sovereignty in your house, but it may not be as safe as it may be elsewhere. Okay, Margo.
So I am so excited that you're here, and that you're probably the only other person possibly in the country, maybe in the world, who's thinking about both international trade law and robotics law. So that's awesome. Welcome. Thank you for being here. So I had three sort of things I wanted to talk about. One is just a general comment in response to something you said. One is a robot-specific framing comment. And the third is, I've been wanting to ask you about this anyway, but just has to do with international trade law. But you brought it up here, so it's fair game. So the first comment is that even though the US claims that it is very pro-free flow of information, we right now have discussions at the ITC about the ITC blocking websites as data flow into the country at the request of the MPAA. So the US is not consistent on that free flow of information point, as usual. Okay, so second is the robot framing comment. I think the most interesting thing to me about what you're talking about with respect to introducing the robotic or the Internet of Things element is the collapse of goods and services, right? It's pointing out that, as we're seeing in many other areas of laws encounters with robotics, the traditional categories just aren't working, and the substitution isn't working. You end up with hybrid things. I'm not sure that the most interesting place to go from that is an anti-protectionism argument. I bet that you can come up with something that's going to talk about a new framework, or at least point to options of a new framework that would be really fascinating, and I'd want to read that paper. And then the third thing, which is my international trade comment / question, is that, I think there's some, and the misrepresentation is too strong, but there's significant eliding in the US discussion of protectionism, trade protectionism, and information flow of the very real privacy problems. So I wanted to know how you would distinguish between regulations, domestic regulations in a country receiving information from the United States or sending information to the United States that target the foreign aspect alone of information flow versus domestic regulations in a country that target the incredibly crappy privacy regime that we have in the United States. So you see this come up in the EU, talks about the EU-US free trade agreement, conversations about the EU-US safe harbor in the context of that agreement, with Europeans not being particularly excited about renewing the safe harbor to encourage flow of information to the United States given the Snowden revelations.
Thanks, Margot. Margot points to the ITC, an acronym that it probably makes no sense to most of you. It's the International Trade Commission, which is a domestic United States entity that manages the kind of regulations of the kind of customs and border control system in the United States. They have, as Margot refers, recently kind of said the word tangible objects might include websites and information flowing across the border. Okay, so tangible has been redefined to include intangible, but that's what we lawyers are very good at. And there's a perfectly credible legal analysis that leads to that conclusion, by the way. So don't get me, don't think that it's just so preposterous on its face that it can't stand. In fact, that's what lawyering is about. So Margot points out twice, I think, issues of hypocrisy. One, the ITC blocking information coming in potentially. Two, she pointing to a third argument, the privacy issues raised by the United States. Even if we're all for free flow of information, there may be some, she didn't actually say this part of it, but some hypocrisy in the United States when we're kind of running around the world, sucking up all that information that is being produced across the world, right? So who wants to have information flow if it just means that the U.S. sucks it all up to surveil everyone in the world? I think that's hugely problematic, and I think the U.S. Has not been consistent on these matters. So I'm not here, even though I referred to the U.S. free trade agenda on that front, I'm characterizing that free trade agenda correctly with respect to those fora that it's describing. But there is concern that the U.S. is undermining the free flow of information by its very actions on the ground. And I think there's legitimate concern about that, and I think the U.S. government needs to be more attentive to those issues. But this shows you really the way protectionism actually ultimately works. That is, what rules the government is always some narrow domestic interest, okay, with blinkers on everything else. Okay, total information awareness, with no concern for, you'll recall this when the Snowden revelations occurred. Barack Obama got before television and said, "Okay, I want to tell Americans that your information, we are not touching your information. We're not looking through your emails, etc." He literally said that. Not those exact words, but that was the effect of what he said. And of course, the fact is, he didn't say anything. He couldn't say anything similar to anyone outside the United States because we had those rules were no holds barred. Okay, so our foreign intelligence laws are only worry about what happens abroad if it captures information of Americans, okay, or U.S. persons in another, if there's some kind of I know that Greg and I may have some differences on these kinds of exactly how we should be capturing all this information occurring across the world. I think there should be more restraints than the U.S. has currently practiced or have been proposed by the kind of more progressive senators in Congress about what we are doing abroad. So the restrictions on mass surveillance are always that are being proposed are focused on mass surveillance of Americans, by the way, just so you know. Okay, so there's a huge issue on this front, and so this may seem I think it's hugely problematic, and the U.S. has problems, but the important thing to realize is that information gathering is occurring all over the world. It's not just happening in the United States, and so we need to focus on that. I need to stop talking and turn over the floor.
My name is Kristen Thomas, and I'm from University of Ottawa. I also don't know a lot about international trade law, but I found this a very interesting topic, and I'm curious to hear if you have any comments or what you think about what might happen to trade protectionism and trade protection laws in the context of cloud robotics and 3D printing. So if I can download and print my robot, and if my robot can gather its information from the internet and I no longer need to import anything, the service or the good, what does that mean for trade laws?
Right. So issues about kind of if it's counterfeiting in some sense, if it's infringing copyright or trademark or etc., where you can essentially bypass all the border controls that you have and just simply have the object created. Print your Louis Vuitton handbag from your printer. That's perhaps a little bit in the future, but that's the kind of thing that we might worry about. So this is a really complicated area, and I don't think there's a clear. This is the kinds of things that lead the ITC to say intangible is tangible. Okay, they are thinking about that kind of future, and they say, well, this distinction no longer makes sense. Let's just obliterate it in order to protect against these kinds of things. Obviously, I am for not having a hugely kind of cumbersome regime for sharing information, including 3D printing patterns, and so I think we need to worry about that. But of course, different states have different rules on ownership of guns. This is the classic example here, right? And so outside the counterfeiting system, so you could see why states might say you can't be circulating that template that allows one of our individuals to actually print a gun, and I think that could be problematic. The difficulty is, as David well knows here in this context, is the issues of enforcement and extraterritoriality. So if the gun model is being produced in a country that allows for guns to be manufactured, and it's being imported into a country that doesn't, can the country that doesn't tell the citizen of the country that allows it to stop doing something that's legal under his or her law? Those are important issues of international law, extraterritoriality, and jurisdiction, and I think that we're going to be struggling with those kinds of issues for quite a while in our increasingly intertwined world, where cyber and robots and information, all these things jumble together across borders.
My name is Dan Jacoby. I'm a labor economist up at the University of Washington Bothell campus. And you may guess from that topic that I'm going to shift you in a slightly different direction. And that is that your framing about information is very interesting. And the question of how we regulate international trade in terms of protection of consumer interests is obviously the paradigm that we use. But there's also the question of protectionism for labor interests, which is a slightly different protectionism, which obviously the threat of robotics is immense, and it begins to have this question about whether there's a blurring of the line between the flow of capital and the flow of immigrants across borders in the form of robotic services. So I don't know how much that's been thought about on the law front, but I would be interested in your thoughts on that.
So this is the dystopian world, right? Where there's something weird about the world where goods and services have greater freedom of movement than people, right? And so there's something odd about this, where bits can travel more readily than people. That's the world that we have today. And so I want to recommend to you a movie called Sleep Dealer, which some of you may have, I think at least one person has seen in this room. So, it's every bit as provocative as Blade Runner. So you should be seeing it. So in this movie, it's a Mexican movie. These people work in Mexico, and they plug in to machines in the United States that they operate, okay, while being physically in Mexico. There's a huge, the wall that actually does exist is a key feature of this movie, as are drones, etc. And one of the things that happens, as you can imagine, a drone operated by one of these people is then used to kill one of these people, another person in Mexico. Right, all kind of mediated through this kinds of world. So that's the scary world that is imagined, and we'd want to be concerned about. That is, if we stop if people can't move, maybe they can still kind of plug into robots in the United States. And in the particular protagonist, he actually works on building a skyscraper, because he inhabits the robot that's building the skyscraper, okay, in the United States somewhere, and so that's the kind of concern. I think we're really struggling with these issues, and I think we really don't have. That is a world that's coming very fast, and we don't really know, because with these kind of broadband technologies, you can have real-time operation of these kinds of telesensing devices across the world. Like radiology has been around for now decades, and telemedicine in general, but telesurgery, where you're actually performing these things, is arising. So these things are becoming, the connections, etc., are becoming robust enough that you can do all these things contemporaneously. So I don't know. It's such a complicated dynamic. So it involves labor law in a way that the stuff that I haven't been talking about involves labor law. But that's in fact the kind of there's a gloomy world, there's a good, nice world, which is people are able to engage in these kinds of activities across the world, despite these kind of immigration restraints, despite the presence of these enormous walls that separate countries.
If I could just follow up just very briefly. I think the bigger question for me is around the term protectionism, as if all protectionism was necessarily a bad thing. Obviously what we look at is intellectual property as being protecting people's investments in intellectual development, but we also think a little bit about human capital, and we recognize that to the extent that we are engaging in this kind of rapid world of technological innovation, then the skills that we invest in are less protected in that process. And so there's this question that arises about whether we need to be incorporating some different kinds of paradigms that recognize partly what people had recognized back when early immigration laws were in place, was that there seem to be some forms of competition which undermine investments and skills, and that you at times you do want to protect those things. Where the borders are, where the boundaries of those, what's productive and what's not productive. But the concern is that if you have very rapid buildup of robotics and you don't have a lot of people having access to the ownership of those robotics, then you are likely to end up with a wider inequality of distribution, which would indirectly affect the consumer well-being.
So Dan, I appreciate that, and I should mention that there are two ways I could have understood your comment, and I understood it in one way. One is, individuals in Mexico operating robots in the United States, or robots coming from Mexico imported to the United States and replacing an American worker directly, right? So two ways to create competition with the American worker, or vice versa, right? And so I focused on the kind of more futuristic or aspect of that. Well, both are futuristic in some sense, and I think both are important. I am, the history, so there's a I don't know how many of you saw the Wall Street Journal piece about New Zealand and Australia, where sheepdogs are being replaced by drones, right? And so it turns out, farmers are buying drones, which are cheaper than employing sheepdogs. And so the question, this is a huge fundamental question for all of us, and that's the kind of fundamental labor question. I'm not one to stand in the way of I think there's a huge nostalgia for sheepdogs. I share that nostalgia, and I don't want to see a lot of unemployed sheepdogs begging on the corners. But I think it's this. We have to figure out how to deal with that world, and I think it's better to recognize that world and then figure out how to deal with the negative consequences of that world.
Responding to your comments about telerobotics, they're particularly useful where it's not advisable to send people, where it's not possible. But if you look at surgical robotics right now in practice, the surgeon and the patient and the robot are all in the same room. The minute you cross state borders and licensing of the clinician is an issue. Is he licensed in the state where the surgery and the patient are, or is it in the state that's transmitting the commands and receiving the information? For underwater exploration, deep sea situations, you're actually outside the 3-mile limit of everybody, perhaps, and you're looking for resources and using underwater robots. Now, where is the legal structure for liability if there's an accident for pollution? We've had a number of those, And so I think along with labor law, there's just simply figuring out whose domain is what and how you deal with these things. Because as I understand it right now, we're not set up for cross-state rather than even international surgery. And robots are certainly being used for underwater activities right now, but without a regulatory structure.
So that's exactly right, and I bet you in WeRobot 10 there'll be a huge amount of discussion of the international components of robots, right?
So I just want to point out something, which is that we had a University of Washington economist ask a question, got a response from a law professor, and then had one of our professors in electrical engineering add flavor to that. And that's the sort of conference we're looking at here. That was just absolutely wonderful. Thank you so much. We're going to take a 15-minute break. Please join me in thanking Anne.
Thanks very much.